Viewers, welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got a partner and accredited specialist at the law firm, John Karantzis. Good evening, John.
Hi Tony, hi viewers.
And also Alisha Muscara, senior lawyer in the law firm in workers' compensation. Good evening, Alisha. How are you?
Good, thank you. Good evening and good evening, viewers.
Viewers, this is the start of our 21st series and also our 9th year on a PI show. So it's been some time, John.
Congratulations, Tony, the longest running law show in Australian history.
It's a good achievement so far, isn't it, John?
It's a great achievement, and it's a testament to you, Tony, as the public wants to hear what we've got to say.
Yeah, no, look, it's important that the viewers are aware of what goes on in our community. We're not only talking about personal injuries, we also discuss other issues.
Oh, yes.
And also, John, we're going to do our new segment as usual. Alicia, you've been involved in the show a few times. We're going to start off, John. Obviously, you wanted to say about the Essendon saga, albeit I'm going to not let you carry on for too long.
No, not too long. But as we all know, the Court of Arbitration in Switzerland has come down really hard on the Essendon 34. Apparently, there may be an appeal of 20 odd players, Tony, but at the moment they're in the Lance Armstrong category. They're guilty, and
Until proven innocent by the sounds
well,
of things.
they're guilty. They can't do anything. They can't play. We'll see what the appeal brings up. But Tony, it just goes to show there is no excuse. Whatever you put in your body as a player, you're
responsible.
You're finally responsible.
Alicia, the only thing I'd like to say about that is if you're getting injected, surely, I mean, any human being would want to know what you're getting injected with, wouldn't you?
I think it'd be reasonable to ask questions. Perhaps not enough questions were asked. At the end of the day, they have to take responsibility. And
anyway, the test is reasonable satisfaction. It sounds to me that this court in Switzerland applied a very, very strict interpretation of the test, whereas the Australian courts applied a more rigid, stricter in favour of the players.
Exactly.
Approach.
I think there was a bit of leeway in the Australian courts, Tony.
Do you think a middle ground would get the players off? Or is it something that's
no. Tony, you can't be half pregnant.
Okay. Anyway, we won't go there. We'll come back to this. We've come back to it so many times. Let's keep moving. There's this incident that occurred in Croatia where 3 young fellows were accused of raping a 17-year-old Norwegian girl.
Shocking.
Listen to this. They managed to get a pardon and come back to their country, which is Australia, by paying her $30,000 compensation as opposed to going to jail. What do you think of that?
It's unbelievable, Tony. You hear of these stories in third world nations, but in Croatia, they've paid off, well, literally it's a payoff for rape charges. 3 young Melbourne men, Tony, they're living freely in Melbourne, and they've paid off the Croatian authorities $30,000 to get off a rape charge.
This is probably the worst act you could carry out on a female, and when the time expires, their good behaviour period, these guys have got the slate clean. How do you feel about that?
It's just disgusting. I mean, things like that just shouldn't be happening in this day and age. I mean, to pay off for something like that, to get off rape, it's just unheard of. And
John, just what surprises me is that they've paid her $30,000, but she's entitled to compensation anyway.
In any event, exactly.
You know what I mean?
Yeah.
If this was in Australia, you'd think they'd do, what, 5 or 6 years?
Oh, easily.
At least?
Yes.
Okay.
Yes.
Look, I find it astounding. Look, we might have to come back to this as well.
Exactly.
Okay. Schools have been evacuated en masse due to quite a few hoax bomb threats in the first week of school, Alicia. I mean, what are the authorities doing wrong here?
I think perhaps teachers need a bit more training in this matter. I don't think anybody foresaw this coming so close to home here. It's affected a lot of schools in Victoria. There's been a lot of schools evacuated over the recent weeks.
Tony, it's ISIS at work again. It's a computerised hoax call to these schools. unfortunately, and as we know, the schools are liable for anything that happens. Therefore, they have to evacuate. I think it's just clear that the evacuation procedures aren't ready, are they, Tony?
No, they haven't really considered it properly. No. And I guess in the process of evacuating, people get injured. There's liability issues there too,
exactly.
Isn't it?
The State of Victoria, the Education Department, they are liable for what happens on the school ground.
Exactly.
So they have to act reasonably, and well, these evacuation procedures looks like they have to have a good look at them.
Oh, I think so. They've got to do a proper risk assessment. Alisha, also, as a parent, you'd think that sending your kids to school, they'd be safe. This raised a lot of issues about safety.
Oh yeah, look, it's affected. I mean, for example, my neighbours and family and friends have had a lot to say about the matter. They've had to pick up their children from school, bring them home, and then trying to explain to these young children what this is, what's going on.
We might have to get someone from the Education Department on board. What do you reckon?
Oh, yes.
All right, John, you're going to love this one.
Yes.
They're pushing for 30-kilometre-an-hour zones. I mean, we're doing 40 and it feels like I'm crawling.
It's the nanny state again.
I'm just astounded how...
As Judge Gordon Lewis said, the outgoing traffic commissioner, he himself said people have trouble at the 40-kilometre-an-hour speed zone, so 30 kilometres an hour.
I find that extraordinary.
Let's relax a bit, guys. It's, I mean, road safety is paramount.
Well,
That's totally paramount, but you got to be reasonable.
Oh, I think so. Just recently, there's been a massive drop in the number of people getting fines in the 40-kilometre zones because now they're aware of them, right? And they realise they're going to get booked. Is this just their way of trying to make more money?
You'd think so. I mean, look, I know that it's been put on hold at the moment. Safety experts are all clashed on the idea, but I think it would be faster to walk.
I'll tell you what, I've got push bikes going past me faster than what I'm doing in the 40-kilometre zones. I mean, what about them? Why don't someone put a brake on what they're doing? Oh, John, if you recall that Grocon incident where the wall collapsed, they've finally been fined, haven't they?
Yes, Aussie Signs, a Victorian company, the subcontractor that put the signs up on the wall in Swanston Street, which unfortunately blew down and led to the deaths of a few people. They were fined $250,000 in the Magistrates Court, Tony, last week. Unfortunately, and that was the same fine that Grocon received also, Tony, the actual contractor on the site. But it's only a quarter of what they could have been fined, Tony.
But also, people have died in this.
Exactly.
And is it enough punishment to deter someone like Grocon?
No.
I mean, you know, the other crowd,
maybe.
They were smallish.
They're a small
and
company.
they could send them bankrupt, but, you know, I think Grocon, who's a billion-dollar company, it's hardly going to hurt their bank
Not
balance.
at all.
And why wasn't someone in authority charged?
Exactly.
Why isn't that a culpable death?
It is. And under the Act, that could occur. However, the Victorian Work Cover Authority have elected not to pursue that course of inquiry, Tony.
It's unbelievable.
Yes.
Anyway, viewers, we've got to go to a sponsors break. Stay tuned. After the break, we're going to give you an update on work cover and also the Fair Work Act. Viewers, welcome back to the show. As we're going to do an update on work cover and also the Fair Work Act. But before that, John and Alisha, I want to talk about this young 24-year-old electrician who went up on the roof of a supermarket in Dallas and was electrocuted to death.
Yeah.
John, can I say this? This happens a lot, doesn't it?
Too often, Tony. We hear it quite often. We receive ourselves clients that have suffered an electric shock.
Oh.
And they've got big claims, haven't they, Tony?
Oh, enormous. That's when they survive.
If they survive, yeah. Because literally they can't ever work again.
Exactly.
But in this case, he's a 24-year-old. He's only got 2 or 3 years work experience. He's on the roof of a small supermarket in Dallas, a suburb of Melbourne. and unfortunately he's electrocuted. And this was on a hot summer day, Tony. This happened, and his family lived around the corner. It was very horrifying scenes for all of them. There was no safety checks performed, Tony. Exactly, and this is a big problem.
Alisha, it's really sad that, you know, the parents of this young fellow, he goes to work, he's supposed to be working in safe circumstances. You'd think they're in the hands of, you know, people that know what they're doing, and their son goes to work and never comes home. It's tragic, isn't it?
It's very tragic. I mean, everybody should go to work feeling safe. These things just shouldn't happen. But unfortunately, in this case, it has.
From my recollection, Tony, a young wife and a newly born.
Oh, that's really
so
that's
they've
really
got
sad.
a pretty big dependency claim, Tony.
Yep.
I understand, from my recollection, the roof was a metal roof, and
Yep.
that acted as a conductor to the electric shock.
And also, I've got another one, John, where a fellow was working on a really big job, big company, and someone switched on the power when he was working on it, and it blew a hole in his arm.
Yes.
And he's very lucky because the electricity actually came out of his body through his arm. But it could have hit his heart, could have hit anything.
Of course.
You know what I mean? So he was reasonably lucky, but he's got no use of his arm.
It's just another timely warning that employers and employees' safety checks need to be conducted prior to the commencement of the work.
And I think what the workers got to know is that don't assume that the employer's done anything right. Just ask them if they've had a proper risk assessment of the duties they're carrying out, especially in jobs like this one, where you're dealing with electricity or water or heavy machinery. Just ask the questions. Has a risk assessment properly been conducted? And get them to show you the paperwork if necessary. I mean, they can't sack you for it, because if they do, you've got a claim for unfair dismissal and you'll get your job back.
Exactly.
So, you know, more questions should be asked. Alisha, can you give us the facts of the first case we're going to do? Murhi and Ford Motor Company of Australia. It's a 2014 Forecourt of Victoria decision.
Of course, Tony. So in this matter, the worker was working at Ford as a welder. He sustained injury whilst working on some portable stairs. He fell almost 2 metres, I believe, and sustained injury to his right knee, lumbar spine, a fracture to his rib, and later on, flowing from that, anxiety and depression. He lodged a serious injury application with work cover for both physical and mental. This went to the county court, where Her Honour found that it was not serious.
Can I just stop you there, Alisha? John, Mr. Murhi applied for a serious injury certificate for the right knee, the lumbar spine, and psychological injuries which were considered serious.
Yes.
In the first instance, Her Honour found against him. Why?
She considered, Her Honour of the County Court considered that he did not suffer serious and ongoing consequences as a result of the injuries. To me, Tony, it looked like that the lumbar spine was the main injury here.
It sounded like it, although knees can be pretty serious too, John.
Exactly. A full-blown hearing occurred here, Tony. The worker gave evidence before Her Honour, and she determined that, well, no, you don't reach the threshold. And it's a high threshold.
Well, he was
isn't it?
heavily cross-examined apparently,
Yes.
and obviously the judge didn't particularly like his answers, Alisha.
Correct.
That's the sad thing about our system, isn't it? A lot of the times, presentation by the worker, and if they can't string enough words together, it will work heavily against them, won't it?
Correct. Cross-examination is a long process. Together with that and the medical evidence in this matter, the judge found against him.
And John, okay, we talk about cases, a lot of cases where people can't put 2 words together. And I really don't mean to be offensive to the public, because sadly not everyone's educated. But I guess if they're honest and present as best as possible and they don't get caught out on a lie, they generally get over the line, don't they?
Exactly. And if you're not fluent in the English language, that's fine. You have an interpreter interpreting to the judge your story. And that's all the judge wants to hear. Your story, how your injury occurred, and how it affects you every day.
Exactly.
At work.
Exactly.
And how the injury occurred from the work injury. Now, if you can't persuade the judge in the county court as to that, really, in essence, it's a simple thing, isn't it, Tony? Then you won't win. And under cross-examination, that is pretty tough. But again,
it can be.
Again, you have an interpreter, and you can answer all the questions and take as long as you like.
Exactly. And also, being beneficial legislation, the courts, as a rule, have to give you the benefit of doubt if there is any doubt, unlike a criminal matter.
In this case, Tony, Her Honour found against the worker. The workers' lawyers appealed to the Court of Appeal, to the Victorian Court of Appeal. Now, it's a very stringent test, isn't it, Tony?
It is stringent. Well, there was 3 grounds of appeal, and the first one was no failure to give proper weight to the medical evidence. Well, what did the court say about that, Alicia?
Well, they've said that the finding didn't come with the definition of the serious injury, and they said that her decision was not wholly onerous.
Wasn't manifestly or wholly onerous. So, in other words, it was within the bounds of the law.
The range.
Yep.
And it was also, the judge gave adequate reasons, and that was another...
Well, that was the second ground.
That was the second ground.
But third ground, which the court was interested in, was the ground where they've applied to introduce further material.
Very unusual, isn't it, Tony?
The Act does permit it, but it's very rare. In rare circumstances, they'll allow it. In this particular case, what was the clincher, John?
Well, Tony, here, the workers' lawyers have asked to put into evidence before the Court of Appeal new evidence that basically the worker needed surgery to the back.
That's pretty significant because when the judge found against this particular worker, she found that he didn't meet the threshold of serious injury.
Correct.
Now, if he needs surgery, that is pretty serious.
Correct, and I think in this matter too, they've considered that the judge did not consider the fact that his back would continue to deteriorate over time.
Exactly. And also there was competing evidence between a number of surgeons. Mr. Dorso on his behalf said that the back was getting worse. There's a couple of other doctors that said maybe not, but the Court of Appeal found that it should be retried, didn't they, John?
Well, that's ideally you'd like the Court of Appeal to say, all right, we'll
substitute.
We'll substitute the judgment, but they've sent it back to the county court, and there'll be another new trial, Tony.
And the reason for sending it back, Alicia, is the fact that there was some conflicting surveillance material, but that's something that can be, hashed out in court again.
Correct.
We're going to go to a sponsors break, viewers, so please stay tuned. After the break, we'll give you some further updates. Viewers, welcome back to the show. We're talking about quite a few cases that have occurred in recent times. The next one's Geelong Leather, Proprietary Limited and Delaney. It's another 2014 full Court of Appeal decision, Alisha. Can you give us the facts of this case?
Of course, Tony. In this matter, the worker was employed by a leather company where he was required to lift heavy hides. The hides, the smaller ones, would range from 30 to 40 kilos, the larger ones almost to 100. His duties weren't changed over time, and he would be doing that constantly for 9 to 10 hours a day. He requested a serious injury certificate and it was granted for pain and suffering. He later went to court over negligence for his employer. He had to prove negligence against his employer where at court the employer...
Admitted fault.
Correct.
Can I stop you there for a minute? John, why did they only proceed on pain and suffering? Because, I mean, it sounded like pretty horrific injuries to his back.
Yeah, we don't know what happened. It most likely probably was an application for both heads, economic loss and pain and suffering. Something's happened along the line, Tony.
Where they dropped the eco loss.
The lawyers for the worker may have dropped the claim for economic loss and was granted a pain and suffering certificate. So we're not sure exactly what transpired there.
Unless he went back to work and they were concerned that he wouldn't satisfy the 40% test.
Exactly.
Yeah, which is pretty strict.
I believe he continued to work.
Oh, okay.
And then following surgery, he couldn't return.
So he may not have satisfied the economic loss test, therefore he's been granted a pain and suffering only ticket.
Yep.
As we know, Tony, this is all about the question of what this injury is worth.
Yep.
Liability was admitted by the employer, which is refreshing. In the sense that, but however, it was still a 5-day jury trial just to assess what the claim was worth.
Well, John, in more instances than not, the employer, when they think they're going to lose, would concede liability for the simple fact that they don't want the jury then to punish them on the issue of damages.
Exactly.
Do you agree?
Exactly. Yes,
Yeah.
I agree.
All right, let's keep moving. The jury's come back after 5 days and awarded this young fellow $385,000. The defendant thinks it's too much. They appeal to the Court of Appeal. Gets to the Court of Appeal. What happens next, Alisha?
Well, it's a great outcome for the worker in this matter. Basically, we get to the Court of Appeal. The Court of Appeal goes through the backgrounds of this case, the history, sees that it is quite a serious injury and finds that it's not excessive at all and finds in his favour.
John, the Court of Appeal said that it's probably a little bit higher than other cases decided similar to this.
Yes.
But they say it's still within a range.
It's not. It's within the range. The appeal by the Victorian Work Cover Authority on behalf of the employer was that $385,000 was perverse, Tony.
Yep.
It was excessive and manifestly excessive.
As compared to, and what's the maximum they can get?
$550,000 for pain and suffering.
So it's at the higher end.
It's at the higher end.
But he's
There's
very
no
young, this
question.
fellow.
He's very young. He's had surgery and he may need further surgery. There was argument about further surgery, and he's had quite a bit of consequences, and that's really what the Court of Appeal looked at.
So
what are the consequences of this injury to this particular person? They've gone through what he complains that his problems are from the back injury, and the Court of Appeal have considered that, you know what, 385 is fair and reasonable in this instance.
Exactly.
And it's a great result for workers. I mean, at the same time, every worker that has back surgery can't say, I want $385,000.
No.
It's not as simple as that.
Well, this fellow was very young, so that's a big
a factor.
Yeah,
but it's a guide, isn't it, Tony?
It is a guide. Alicia, $385 sounds like a lot of money, but just for someone that's got to live another 30, 40 years in the workforce, if they can work, and also put up with this and affect their day-to-day activities, doesn't sound like a lot of money, does it?
No, in the long run, I mean, compensation's never going to bring back his health. He's had a surgery, a second surgery's on the cards, and at the end of the day, it might improve his ability to be comfortable.
Or give him some security, a little bit of security. Albeit he can't really buy anything with it. He wouldn't be able to buy a house.
No.
John, it just raised another issue.
Yes.
These cases are very complicated, aren't they? And there was the issue about echo loss and pain and suffering, and should they have dropped the echo loss? You're an expert and specialist in workers' compensation and in Carbone lawyers. What do you suggest the viewers do if they've got an injury of whatever magnitude?
Tony, a work injury, particularly where you've suffered a back injury at work, you need surgery, you've had surgery, you're entitled to compensation. You should give us a ring at Nwiki Carbone. We're able to assist and help you with your claim for compensation, for lump sum compensation for the future wages that you'll lose and for pain and suffering, Tony.
That's it. And we've got a very well-trained team of people that will give you more than one opinion.
Exactly. It's a claim for weekly payments, for medical expenses, and also for lump sum compensation.
Exactly.
Now, not everyone is entitled to all those benefits, but that's where you need to ring viewers and injured workers especially and find out what your entitlements are.
And get people that know what they're doing, because, I mean, been in court quite a bit, obviously.
Exactly.
All right,
this case would have cost, 5 days before a jury trial, Tony, it's 150 grand in legal costs.
At least. Sadly, the worker would miss out a lot of that 385, or a fair chunk of it would have gone in legal fees.
That's right.
Which is sad, isn't it?
It is.
Yeah. But that's the system, viewers. You can't do anything about it. Okay, let's get on to this FBS International Protective Services Australia and Maritime Union of Australia. The facts of this case, Alisha, just basically.
Basically, the employer let 49 of their employees go. They made them redundant after losing a contract. They say they then assisted them in obtaining further employment, and in doing so, they then made application under Section 120 of the Fair Work Act to have a exemption of paying them redundancy.
And John, the court said what?
It's a bit cheeky of them, didn't they?
Yeah, well, I mean, they didn't really do much, did they?
No, you got to pay the redundancy, and the court found that the employer is required to pay redundancy. I mean, it's just, yeah, it's a bit cheeky of the employer to do this.
Well, all they did was provide a list of their contact details.
Exactly.
They made some arrangements for the employees to meet. They don't know who met who.
Exactly.
And there was unsuccessful attempts to engage with discussions between the two employers, and they said that that gives us the exclusion not to pay redundancy, which is outrageous, isn't it?
Exactly.
Just quickly and lastly, before we go, because time's flying as usual, Dowka and DP World Melbourne Limited. Well, in Dowka, viewers, this is where an employee or employees applied to the court for anti-bullying protection. In other words, they've been bullied at work, they've applied to the court for a stop bullying by the workers, and in those circumstances the court granted the orders. It doesn't entitle you to compensation, John.
No.
However, if the bullying continues, then what can you do?
Then you may have a claim, Tony.
Exactly, under the workers' comp legislation.
And the Fair Work Act.
Exactly.
Yes.
Alicia, so you can stop the bullying by applying to the court, and then that gives you rights down the track if it continues.
Correct.
I mean, that's as good as it gets.
Yes, and I mean, you should always lodge a claim as soon as possible if there is anything that you feel as though is serious and ongoing in your workplace.
Well, viewers, it's been great to be back on set. And viewers, it's our 9th year, and it's been great presenting to you, and I hope you're still getting a benefit out of it. I know that quite a few of the universities and students are watching it, John, which is good.
All the time.
Viewers, go to our social media platforms, catch up on our past episodes on YouTube, stay tuned for future episodes, and always remember to stay safe.